Ano ba yung mga different types ng mga intellectual property?
So basically, pag intellectual property, you would refer to rights of creators, no, with respect to their creation.
So yung
Oo.
mga codes pattern can be patented?
General rule, copyrightable. Pero there is a way to register yung mga software programs.
Naisip ko lang, attorney, no, hindi ba magiging hindi na secret kung ipa-file mo yung trade secret mo?
Yes. Actually, it's the choice of the inventor, of the applicant, whether to have it patented or keep it a secret. Kasi may pros and cons.
Marami tayong mga entrepreneurs na nag-try mag-business lang, no? And meron silang minsan misconceptions about intellectual property. Ano po yung mga nakikita nyo?
Since startup lang kami, we don't need, no? Parang we don't need any of this kasi additional cost lang sa amin to. Which is medyo disappointing. You don't need to do anything to obtain copyright protection. It's automatic.
Hi everyone, this is Jerry Ilao, co-founder of Olearn and Atty, and welcome sa ating Olearn Insights, where we distill business strategies and tech into bite-sized learning. I'm here with Atty. Tito Bundang, Managing Partner of SVBB Law Offices. Hi Attorney, good morning.
Morning, Jerry.
Yeah, thank you so much, Attorney, for being here
Yeah.
sa ating Olearn Insights.
Very glad to be invited also.
Yes, I'm very excited ako, attorney, kasi intellectual property yon. Somehow is close to my heart. I love to, in a way, parang create brands, and I want to protect, syempre, yung business, yung brands. So, very excited for our viewers, no, mga entrepreneurs. I'm sure they will learn a lot dito sa ating segment.
Yeah.
Sige, siguro to start with, attorney, no? So, can you tell us more about SVB Law Offices?
Okay. Well, our law office, SVBB, we started 1976.
Wow.
Actually, started by our founders, si Eugene Tan and Ignacio Sapalo. They started with the practice of intellectual property already, along with maritime and labor, no? And then eventually, nag-evolve na kami with the... Actually, we just celebrated our 49th anniversary, no?
Wow, congrats.
Last
Grabe.
week, no? And we're into... Aside from, of course, intellectual property, still our main practice, we're still into maritime labor. Of course, partly commercial law, basically corporate tax practice.
Okay.
And which hindi naman mawawala sa lahat ng law offices would be the litigation in general practice. So these are the main four areas that we are into now.
Okay. Ngayon, attorney, no, so pag-usapan natin yung intellectual property. Siguro for those na, yan, medyo bago sa business, ano ba yung mga different types ng mga intellectual property?
Okay. So when you, basically, pag sinabi mong intellectual property, you have the main categories. Basically, you have copyright, trademark, patent. Patent may also would include what we call utility model, industrial design.
Okay.
Okay. And then, of course, meron pang ibang areas like trade secrets,
okay,
no? And geographical indications, no? So basically, pag intellectual property, you would refer to rights of creators, no? Mainly with respect to their creation. So iba-iba lang yung terminology, kung copyright, kung trademark, kung patent. Basically, gano'n, no? Yung relationship between the main creator and the creation.
Okay, okay. Now, when you say about trademark, ano po yung tini-trademark? Kasi common yung trademark and copyright. Di ba? Minsan na-interchange. Anong pagkakaiba ng iba?
Well, basically, pag sabi mo trademark, you are into symbols, no? So, dito, ang requirement dito would be any sign that is visible and distinctive.
Okay.
So you can actually register as a trademark can be letters, numbers, combination of letters and numbers,
yung mga
logos, photos, slogans, 3-dimensional, 2-dimensional, basta anything, no? Kahit mga shapes, more or less pwede naman siyang, may mga konti lang mga limitations, pero basically pwede mo siyang ma-register as a trademark. No?
Okay, okay. Tapos yung copyright, attorney, related lang ba sa literary work?
Yes. Basically, pagka-copyright, ang protection mo dyan, it would extend to what we call original literary and artistic works.
Okay.
So that could be mga libro, articles, paintings, sculptures, drawings, no? Mga write-ups, no? What you see basically online, di ba? Yung mga any write-up there, any articles basically, ano yan, copyrightable yan. No? So actually, malawak din yung coverage niya, but medyo ang kanyang extent lang, ang parameters would be original literary artistic works.
Okay, okay. Tapos yung patent naman, attorney.
Okay.
Ano yung patent?
Ang patent, ang slight difference naman niya would be, ang definition mo kasi ng patent is, it should be a technical solution to a problem. No?
Technical solution.
So
okay.
therefore, pag sinabi mong patents, you are referring to inventions. No? So inventions would be, merong siyang criteria, no? Para siya ma-register mo as a patent. Kailangan siya, merong element ng novelty, kailangan bago, kailangan merong inventive step, yung medyo something very different na hindi ka easily recognizable, no? Yung tawag doon, non-obvious.
Okay.
And then the last element, yung industrial applicability.
Okay.
Kailangan pwede mo siyang magamit sa industry, useful.
Okay. Yung mga, kasi we're in a software business, no? So yung mga codes, attorney, can be patented?
Ang rule kasi dyan, general rule, copyrightable kasi considered siyang language.
Okay.
No? Pero there is a way, especially for patent, no? Merong paraan to register yung mga software programs for as long as you connect them with the hardware. Since I don't have a technical background, what we do is we have technical people who can more or less look into all of this. Paano pwedeng i-patent yung mga programs. No? But as a general rule, kasi pag program, you speak of copyright.
Okay. Tapos yung last, yung trade secrets.
Okay.
Ano naman yan, attorney?
Well, trade secrets, talagang secrets, no? Something that you keep within your let's say company, pero nagiging trade secret siya because it provides you with an advantage, no? Against your competitors, something that you, parang confidential information that you really exert effort para talagang konti lang ang nakakaalam, parang ikaw lang, no? Kasi pag hindi mo siya sinafeguard, hindi siya mako-consider na trade secret eh. So kailangan you've come up with some steps to really protect it and to keep it a secret among yourselves. Kung meron kayong kumpanya, yun nga, it's an advantage. Meron siyang value kasi ito yung parang advantage mo sa mga competitors mo.
Okay.
Na pag nalaman ng iba, wala ka na, nawawala yung advantage mo sa kanila.
Okay,
no?
sige.
So it could be any information, data, anything, no? Know-how can be considered as trade secret.
Okay, okay. So pwede din process?
Yes, pwede
process
din. Yeah.
Na, let's say nag-design ka ng process, specific process sa company?
Yes, oo. Okay. Diba ang very common ngang example dyan, usually yung Coke. Diba?
Yes.
Coke never patented yung kanyang formula.
Yeah,
so it kept it as quote-unquote trade secret.
Okay.
No? But of course, hindi na siya trade secret. Kaya mo na siyang i-reverse engineer, di ba? Pero at the start, ganun talaga. Hindi naman mahirap talaga siyang malaman kasi among themselves and merong mga anecdotes nga kung how they really kept it as a secret. No?
Yes.
Tinatago nila, ilang tao lang yung nakakaalam, mga ganun. So
yung mga secret sauce na kung let's say may nilalagay ka dun sa pagkain can be considered trade secrets. Okay. Naisip ko lang, attorney, no, hindi ba magiging hindi na secret kung i-file mo yung trade secret mo?
Yes. Actually, it's the option of it's the choice of the, if we call it a patent inventor na, no? It's the choice of the inventor, of the applicant, for example, whether to have it patented or keep it a secret. Kasi may pros and cons. No? May pros and cons. Pag pinapatent mo kasi, basically, you disclose everything as a rule. No? You disclose everything. And then, ang kapalit naman nun is you are given some sort of an exclusivity, parang monopoly ng gobyerno. For a certain period of time, you are authorized to prevent others from using it. So, may pros and cons. Ang problema lang kasi sa trade secret, madaling mawala yung pagiging secret niya. Kasi pag may nakakita lang na ibang tao dyan,
Yes.
wala na, tapos na yung protection mo. It's known to everyone, di ba? Parang ganon. So, it's your choice actually, how you want to proceed, no?
Okay.
Oo.
Okay. Yeah, thank you so much, attorney. So, yun, we've clarified mga different types ng intellectual property,
Yes.
no? The trademark, patent, copyright, trade secrets, yun. I hope clear na sa audience natin. Yung next naman, attorney, na gusto ko sanang pag-usapan is about common myths ng intellectual property among Filipino entrepreneurs. Kasi, yun nga, yung marami tayong mga entrepreneurs na, alam mo yun, walang, kumbaga, nag-try mag-business lang, no? So, walang background talaga into law, etc. And meron silang mga, minsan, misconceptions about intellectual property. Ano po yung mga nakikita nyo?
Through my decades of practice, malaki na rin ang improvement, no? Marami na rin entrepreneurs who are aware of intellectual property. But mostly yung mga wala sa urban areas, no? Ang usual comment na na-encounter ko dito is mahal. So magastos, no? Sabi nila magastos. Tapos number 2, parang since startup lang kami, we don't need, no? Parang we don't need any of this kasi additional cost lang sa amin to. Which is medyo disappointing kasi in fact, if you are starting up, you should look into your intellectual property already, no? Kasi you have to look at it as an asset, eh.
Yeah.
It's also a way of promoting parang brand identity, no? This is the best time habang nag-umpisa ka. Kasi usually, ang nangyayari, pag lumaki ka na at meron ng kumopya ng trademark mo, for example, doon ka ngayon magrereklamo, bakit ginagamit niya yung marka ko? Eh, pareho kami ng produkto, pareho kami ng marka. Eh, kasi it's open to everybody. You did not register it, di ba? Same thing with copyright, no? Bakit hindi mo in-assert, for example, yung mga composers, di ba, habang nag-uumpisa sila kasi they want immediate payment. Sige, bibigay na lang namin, bahala ka na mag-promote ng aming music. Tapos pag sumikat na, wala na, hindi na nila ma-claim kasi hindi na kanila eh. Binigay na nila yung all their rights over the song, no? So, very important that you're aware of your intellectual property rights, and of course, at the same time, kailangan at umpisa pa lang, try to exert effort to protect your trademark, copyright, or even your inventions.
Yeah. So, I think, yun, nakakita ko, no, parang naririnig ko rin na mahal nga o magastos. Pero magkano ba, attorney, yung talagang magpa-file ka ng trademark or kaya patent or copyright?
Kung if in terms of government fees, hindi naman siya ganun kalaki, no? For example, trademark, siguro you'll be spending less than 10,000 for government fees and all expenses, no? And then for patent, siguro higher, siguro double or triple, depende, no? Ang lumalaki lang kasi nagkakaroon ng professional fees, no? So depende kung sino yung kausap mo na trademark and patent lawyer. So nadadagdagan yun because of the professional fees. But then again, part of kasi ng lalo na sa lawyers, meron din pro bono, no? So if you can show usually na small and medium ka lang or you really cannot afford, I think most lawyers would even provide advice, no? And assist you entirely, lalo na kung trademarks, very easy because you can do this online. So ang support na lang basically would be yung once na nagkaroon ng, kasi ni-examine yung trademark application and yung patent application. So siguro, during the examination process, dun ka na lang kukuha ng kailangan mo ng medyo may alam na lawyer who can assist you, who can guide you how to obtain protection.
So, hindi din, kumbaga, very reasonable, no?
Reasonable naman talaga siya.
Sabi mo nga, asset siya. Especially kung lumaki yung business, diba? Magiging very, very valuable yung trademark na yun. Yeah. Usually, attorney, how long ba yung process? Let's say, nag-apply ka ng trademark.
Okay. For trademark, which you need to register, siguro it will take you, depende, no? 6 months to mahaba na siguro yung 2 years. Yung patent, medyo matagal because of the required process. Meron tinatawag na kailangan pa ng prior art search, titingnan pa kung talagang bago yung invention mo, compare sa mga existing prior art. And then, siguro, it will take you kung patents, minimum of 3 to 5 years
so matagal,
for you to get the registration. Yung copyright, siguro, Jerry, I just want to mention, a lot of people don't know that you don't need to do anything to obtain copyright protection. It's automatic. So once you have the work, you call it a work. Pag copyright kasi it's the author and the work.
Oo.
Once you've come up with your work, it's automatically protected.
Oh.
So kanya, kung meron
okay.
kang sulat, meron kang write-up,
Oo.
pag nagawa mo na yung write-up mo, it's copyright protected na.
Oh.
You don't need to register.
Okay.
Though there is a process to register.
Okay.
If you want to register, para lang meron kang record,
Okay.
para you can also show to third parties later na, ako yung gumawa nito, no? Para madaling maniwala na ikaw ang gumawa. Kasi baka hindi maniwala eh. So at least meron kang preliminary proof, no?
Okay.
Na ako ang gumawa niya, no?
Okay.
But you don't really need that
to
obtain the copyright protection.
May nakikita ko, attorney, sa baba, no? Parang copyright something.
Yes.
Do you need to put that to claim copyright?
It's not a requirement, but it is suggested.
Okay.
That you put a copyright notice.
Okay.
Na for example, lagay mo doon, ano yung usually nilalagay mo doon yung date, kung kailan mo na-publish, no? Yung place, tsaka sino yung mismong gumawa, yung author.
Okay. Okay. Tanong ko na rin to, attorney. Sa website kasi nilalagay namin yung copyright. No?
Yes.
So, let's say kini-create yung website 2015. So, may nakita ko 2015 to 2025 ba? Ganon? Or 2015 lang kung kailan mo create?
Kasi minsan, pag website, siyempre, minsan, hindi naman siya static.
Yes,
so, may mga changes ka.
Yes.
So, ginagawa nila, every year, nilalagay nila yung year. Kasi pag may change, ibig sabihin, parang bago na to in a way, pero akin pa rin to since 2015 or parang gano'n.
Okay.
I started 2015 up to the present.
Okay.
Tapos di ba makikita mo sa mga, even sa mga movies, all rights reserved. Yun.
Yes.
Kasi pag sinabi mong copyright, madami kasing rights eh. Hindi lang isa eh. So you have so many rights that are granted to you by law. So therefore, nilalagay mo na pag ikaw yung author, I have all these rights. You need to get my consent. Kuha mo yung consent ko para you're allowed to exercise these rights.
Okay.
No?
Okay. Tapos, attorney, no, yung isa din na parang naririnig ko is first to file.
Yes.
No, can you clarify ano bang ibig sabihin nun?
It's just a rule in trademark and in patents. No? Pagka first to file, ikaw yung unang nag-file ng application, you are given preference and priority in terms of examination ng IPO. Ang IPO is the Intellectual Property Office of the Philippines who's in charge of all this. Would administer itong mga IP rights and IP concerns. So yon, ikaw lang yung priority. So pag may nag-file na sumunod sa'yo, for example, ng application, similar trademark covering the same identical goods and services, so ikaw lang yung examinin. At siya, most likely, hindi mo na siya papansinin. Kasi nauna ka kamukha eh. And you're given priority. Sa patents, ganun din, first to file. Pag ikaw ang nauna, kung merong sumunod na nag-apply basically for a similar let's say, invention, then ikaw pa rin ang mauuna. Ikaw muna ma-examine and in all probability, ikaw makakakuha ng registration. It's just a rule, no? But it does not mean na, kunyari, ikaw na yung nakakakuha ng registration. It does not mean na ikaw pa rin ang owner kasi baka mamaya bad faith ka din, di ba? Kung may presence ng bad faith, kunyari, yung isang trademark, ni-register ko, pero actually, kinopya ko lang yung trademark na yun sa US or somewhere. Di kahit ma-register sa akin yun, eventually, you can cancel it. You can have it canceled. Pwede mo akong i-demanda, ipa-cancel mo yung registration ko kasi I acted in bad faith. Parang gano'n.
Okay. Ayun. So, ang dami nating napag-usapan. Thank you so much, attorney.
Yes, of course.
Simula pa lang po yan ng intellectual property, kumbaga 101 for entrepreneurs. In the next segments, pag-uusapan natin yung mas detail how to file your trademark, and then we'll also talk about content, online digital content for content creators, etc. So, again, maraming salamat, attorney.
Thank you, Jerry. Thank you, Deb.
Iyon. So, please watch the next episodes ng ating Olearn Insights. By the way, attorney, for those pala who want to get in touch with you, who want help sa trademark or even yung mga other services, where can they get in touch?
They can just email me, or they can check out our website sa Palo Veles Bundang in Bulilan, or email me at tito@sapaloveles.com.
Ayun. So, we'll put that in the description. So, again, this is Jerry Ilao, co-founder of Olearn and Tarki, saying, if learning is not your priority, don't expect change. See you in the next video.